All rise. 14th Circuit Court resumes. Please be seated.
Okay, let's go on the record in People versus Bluhm, file number 17-1007. This is the time scheduled for the court to consider a motion regarding bail and a motion to quash. Parties have had some preliminary discussions with the court and chambers on this matter. We can proceed. So it's your motion, Mr. Hayes. Go right ahead.
Thank you, Your Honor. With regard to the motion to quash, primarily I'll rely on our pleadings. I would like to state that the interesting note from the preliminary examination is that the state has no evidence against my client except for his own statements. In addition to that, Your Honor, the state admitted that Mr. Bluhm's statements produced no new evidence either against him or against Mr. Willis in the disappearance of Jessica Heeringa. So that gives rise to our corpus motion. But in addition to that, at the preliminary examination, if you would note, the state is indicating that they are aware or they believe that Mr. Bluhm's statements, some of them were false. They're very strong belief. So the state's making these arguments as to false statements. At the same time, they're relying on the truthfulness of the statements for the conviction in the case at bar. And that gives rise to both the collateral estoppel argument and the due process argument. Essentially, they are relying on his truthfulness to convict him, but yet they've already convicted him of lying to the police officer in the same transactions or circumstances. And they're taking opposing arguments, they're taking opposing positions on the same issue, which is our due process argument, Your Honor. With regard to bail, my client's been in jail for...
Well, your due process and collateral estoppel.
That's correct.
Yeah.
Yes, thank you. With respect to our argument on bail, pursuant to the court will cite in the pleadings, Your Honor, my client has been in jail for 494 days consecutively. This exceeds both the court rule allowing for a speedy trial outside of some special exceptions which have not been presented to this court, and also exceeds his anticipated guidelines on the underlying charge. So we're asking the court to consider those factors and award my client a personal recognizance bond.
What is the bail now?
It's $150,000 cash or sure.
Okay.
Thank you.
All right, thank you. Mr. Roberts?
Thank you, Your Honor. Well, I'm going to start by indicating to the court that my intention is to confine the arguments I'm making today to the record that was established at the time of the preliminary examination, not talk about other things that may or may not be presented as evidence in the case. And to the extent
well, yeah, it's a motion to quash, so it's right. Based on what we did at the prelim.
And to the extent that the evidence that was presented against Mr. Bluhm at the time of the preliminary examination was his statements to the detectives during the course of the interrogation that took place, that's how I will be framing our argument today, because that is what the prelim was based on. The bind over was based on those arguments. As it relates to both the due process and the collateral estoppel arguments here, the crux of Mr. Hayes' argument here is that you can't say that my client lied and told the truth. And the simple answer to that question is yes, you can say that. As the court is well aware, the jury instructions will instruct a jury sitting in a case that you can believe all, part, or none of a person's statement. And it's up to them to decide what is true and what is not true.
Okay, well, let me just stop you right there. Here's to me, this is the crux of these collateral estoppel and due process arguments. I want to be clear. It's my understanding that Mr. Bluhm, matter of fact, it was done in this courtroom, was convicted of lying to the police.
Yes.
And this lying to the police charge arose out of an interview that he had with the police. And during this interview, he made several statements. And if I understand this is correctly, there were certain statements that he was charged with lying in the course of that interview. And he was convicted of that and actually did some time in jail over that, as I understand it. Now, you're now alleging that during that same interview, if I understand it, he made some other statements that you find to be true that are evidence of his involvement as an accessory after the fact. Do I understand this correctly?
Yes.
All right.
But
what I want to be clear about is, if you are contending now that he's an accessory after the fact and basing it on his admissions or during this interview, and they are the same statements that you contend that he made were false before, then I think we've got some issues with collateral estoppel here that are viable in this case. But if you are saying that he made a lot of statements, some of which were false, which we convicted him of, and some of which were true, which we are using to support our claim of accessory after the fact, then that's, in my view, likely not collateral estoppel. So I need to know, are these different statements that support the accessory after the fact charge than the statements that were used to convict him for lying to the police?
Yes, and in part, the answer to that question is yes. But part of the explanation for that is this: that one of the charges that was filed against Mr. Bluhm was for lying about Mr. Willis's involvement with a separate homicide, and I don't think even Mr. Hayes would disagree with me that those statements are not really subject here, and that there was actually 2 interviews that took place of Mr. Bluhm over the course of this investigation. So those.
But the accessory after the fact is to the alleged homicide involving Jessica Heeringa.
Yes.
All right.
Yeah.
And apparently he made statements involving also Mr. Willis's involvement with Rebecca Bletch.
Correct.
All right.
Yes.
Those are not on the table here for the accessory after the fact.
No, those are not.
All right. Now, the lying to the police charges involved his statements about what?
The lying to the police, I haven't brought the 2 files down with me, but I could go back and check this to be certain. But part of the lying to the police charge that related to the Heeringa investigation was related to Jeffrey Willis's role in that. In later statements throughout the course of that interview, Mr. Bluhm admitted to his role in that, and that's the evidence that was presented at the time of the preliminary examination.
On the accessory after the fact.
Yes.
But my point is, the statements that he was charged with lying about did not relate to his involvement as an accessory after the fact. It related to Mr. Willis's involvement in the homicide of Jessica Heeringa.
Right.
Okay.
And I understand it presents an interesting scenario for the jury, for Mr. Hayes to argue that you can't say he's
that's a
lying
different
and
issue.
telling the truth.
This is a motion to quash here.
Okay. But as I said, we have to confine it to the record. So as it relates to the collateral estoppel and the due process arguments, the short answer to the question is we do believe some of the things that Mr. Bluhm said, and we don't believe some of the things that Mr. Bluhm said. And both of those statements by Mr. Bluhm, I'm confining it to 2, but the court sees my point here, that both of those things related to the charges that were brought against him here. As it relates to the corpus delicti, the solution to the corpus delicti problem is actually quite simple. People v. King, 271 Mich. App 235, very clearly states that the corpus delicti rule, for purposes of establishing the protection that is offered by the corpus delicti rule, which is to stop a person from confessing to a crime that did not take place. The purpose of the corpus delicti rule as it relates to an accessory after the fact is the accessory after the fact corpus delicti is the same as the underlying crime itself, and that's the argument we made at the time of the preliminary examination.
So you're saying you had the corpus for the murder?
Yes, that you don't have to have separate corpus delicti for accessory after the fact. So we presented to the court, or stipulated to the court, I should say, at the time of the preliminary examination, the roughly 4 days worth of evidence that was already presented to the court in the Jeffrey Willis trial involving the Jessica Heeringa disappearance and murder as the basis for establishing that a crime had taken place, and then used Mr. Bluhm's statements at the time of the preliminary examination.
Okay,
so the corpus delicti is satisfied in that there was corpus delicti for the underlying charge, which was Mr. Willis having murdered Jessica Heeringa.
Okay.
So there is not a separate corpus delicti, not a separate.
I understand.
Corpus that needs to be offered. Finally, Your Honor, as it relates to the bail issue, as I indicated to the court in chambers, the people's position is the same as it has been from the very start with this case, is that the bond is appropriately set, and that the only thing that's different now between when we were last here, and I think we've already argued this motion once in front of the court before, is the passage of time. But as I've repeatedly said to the court, time and time again as it relates to this case, this is not your average everyday accessory after the fact type case. And the reasons why we felt that the bond needed to be high in the first place was because our belief that Mr. Bluhm has information in his possession which could be very detrimental to the court did to the state's case in moving forward in the prosecution of Jeffrey Willis for the Jessica Heeringa case, and that being the location of Jessica Heeringa's remains. And for that reason, we believe that Mr. Bluhm does represent a public safety threat here. And I think it's counterintuitive to argue otherwise, that an individual who's willing to help somebody get away with the crime of murder is not a threat to public safety. Mr. Bluhm is that person. He's related to Jeffrey Willis, and he has information which could be used in a harmful way to the state's case moving forward and prevent the eventual hopeful recovery of Jessica Heeringa's remains. So again, aside from the passage of time, nothing is different now from when this bond was originally set and then revised by the court at the time that and I think this court is the one who actually lowered the bail, or at least at the time of the preliminary examination, it was lowered from $250,000 to $150,000.
Okay, well, let me ask you this. All right, but the passage of time is significant. Mr. Hayes is correct. And particularly it's significant in light of the speedy trial rule, which says that the court must release this man on personal recognizance at this stage in the proceedings unless I find by clear and convincing evidence that he's likely either to fail to appear, and I don't think there's any evidence of that, or that he presents a danger to any other person or community. And that's, I think, what you're resting your hat on here.
Yes.
Now, what is your evidence that he's presenting a clear and in other words, what is your evidence here? You're saying it's your opinion that he's aware of the location of the body in the Heeringa homicide investigation. Now, that would be a clear and present danger to the community, in my opinion.
Yes.
But the question is, what clear and convincing evidence do you have that he is aware of the location of the body or assisted in the disposal of the body? What is that clear and convincing evidence? Is that what you presented at the prelim?
Yes, because of,
because
of his
that's what I need to know.
In doing this. And
what?
Within that, and there's two aspects of it.
All right, sum up for me the evidence you had from the prelim.
Mr. Bluhm told the investigators, I know where she's buried, I will take you to her.
Okay.
The short answer is that. There was more detail to it than that, obviously, but then the investigators were present when Mr. Bluhm actually calls his wife and says, I'm doing something I should have done years ago, I'm going to take him there, I need you to quit my job for me. All of these things are the reasons why investigators believe that he's being truthful in knowing that where this body is buried. He didn't take them to that location, or at the very least the body had been moved since the time that he went to that location. But within within him having that knowledge, it really represents two problems. One, the danger to the case in moving forward, but this is a person who is willing to help somebody commit murder. That's why we believe that Mr. Bluhm is a threat to public safety.
Okay, now,
Thank you.
give you a chance to be heard.
Your Honor, if you review the preliminary examination transcript, you'll see that Lieutenant Cashew, who was the lead detective at the time, testified that he believed wholeheartedly, unequivocally, that Mr. Bluhm was lying to him about knowing about the location of the body. It's not clear and convincing. In addition to that, Your Honor, the burden at the preliminary examination is...
Oh, wait a minute. Now you've got me confused. Cashier's opinion is that your client lied when he said he knew the location of the body. I thought that's what you're basing this on, is that he told the truth when he said he knew the location of the body, and therefore he's an accessory after the fact.
Well, I think Mr. Hayes, frankly, has me confused a little bit at this point, too.
Your Honor, that's black and white in the transcript. He believed that that's part of the reason. It also goes back to the collateral estoppel due process argument. They're throwing things against the wall. I don't care what they think is true. They have their opinions.
Okay, but
the same issue.
But I need to get this resolved.
Okay.
This is a critical issue to me. My understanding of what your position is, Mr. Roberts, is that if Mr. Bluhm knows where this body is, or at least at one point knew where the body was, and the reason you believe that, primarily, I realize there's other corroborating factors, is that he told the police he knew where the body was.
Told the police and went into some detail about how he helped Jeffrey Willis dispose of the body.
And there were that helped corroborate the believability of that. Now, what I'm hearing from you is, you're saying the police said he's not telling the truth when he says he knows where the body is?
Absolutely.
So,
That's clear.
Right.
Your
Now-
Honor. May I add on to that?
just a minute, I don't understand then, why are you saying that you're taking the position the police are wrong too?
No, I'm not.
Here's my point. I've got to find clear and convincing evidence that he's a danger to the public. And if he knows where that body is, or knew where the body was, or helped him get rid of the body, and there's clear and convincing evidence, that is a clear and present danger to the public. I agree. But what is that evidence? You're telling me you want me to rely on evidence the police themselves don't even believe is true?
Well, first and foremost, I think Mr. Hayes is kind of putting words in Lieutenant Casher's mouth, or basically accusing Lieutenant Casher, accusing is not the right word, but saying that Lieutenant Casher is a human lie detector test, when he's being lied to and he's not being lied to. I think what Mr. Hayes is getting at here is that the location to which Mr. Bluhm took investigators after his investigation did not yield the body of Jessica.
Okay.
That doesn't undercut in any way our belief that Mr. Bluhm knew, at least at the time he disposed of that body, what that location was. Now, whether or not Mr. Willis moved it after the fact is I suppose, a possibility, a possible explanation to why the body wasn't there. But in no way, shape, or form do investigators have any doubt that Mr. Bluhm helped Mr. Willis dispose of this body.
Okay.
The precise location of where that took place is obviously of some debate, because the body has not yet been located.
Okay. All right, thank you. Go ahead now.
Thank you. He made it, we're talking about clear and convincing evidence. And that is different than preponderance, which is the standard at the preliminary examination. So just because evidence was presented at the preliminary examination, which survives the preponderance test, doesn't say that same evidence would survive a clear and convincing test. So I'm asking the court to consider that, and not just any evidence that was presented at the preliminary examination. But
it's a probable cause test, not preponderance test.
Well, okay, probable cause more likely than not.
All right.
Thank you for the clarification, Your Honor. But my point is, Mr. Bluhm made a statement. I know where the body is, I'm going to take you there. He took the police there, there was no body. Not only that, Detective Casher said there was never a body there. We took cadaver dogs there, there was no fresh unearthed. Prior to getting there, Mr. Bluhm described it, trees and stuff, which didn't exist, Your Honor. So now, Detective Casher believes that he was lying about that statement. But now Mr. Roberts is saying, well, just because he made that statement, now we want to assume that he knows where the body is based on statements he didn't make. His statements are, I know where the body is and I'll take you there. He took him there. There was no body, no evidence that the body was ever there. So there was, the case was bound over on a multitude of factors, not just that issue. If that would have been the only thing that they had, this case wouldn't have got bound over, because the detective clearly didn't think the body was buried there. You can't assume that he knows where it's at if the place that he says it's at is determined to not be a true statement. You can't now assume, well, he must know where it is then. So that's why I say it's a lie. You can't assume that. In addition to that, there was evidence presented at the preliminary examination, which on that night in question, first of all, they don't even know what night anything happened except the night that the young lady was abducted. But the night they think she was buried, they have cell tower records of Mr. Willis somewhere in northeastern Muskegon County. But they don't have my client's, the evidence was they didn't have my client's cell phone pings in that area. So the evidence doesn't support in any fashion that he knows where the body is located. And for the court to make a ruling today that by clear and convincing evidence he knows where the Jessica Heeringa body is absolutely wrong. There's been no evidence that he knows that. In fact,
Well, except his own statement that he does.
which the police, his statement was, I know where it's at, I'll take you there. And they found that to be a false statement, Your Honor. He didn't make any other statements. Oh, I know where it's at, it's somewhere else. He said, I know where it's at, I'll take you there. And that was determined to be a lie. He didn't make any other statements. It's not an abstract, well, he took us to the wrong place, but he must know where it really is. That was never presented. There was no evidence that presented that. The evidence was he made a statement about the location of the body, but that statement was believed to be false. And that's clear in the transcript, Your Honor. It's clear. So for them to now say, well, he must know where it is, and we believe that he knows where it is not based on my client's statements, not the specific statements about the location of the body. My client made a lot of statements, Your Honor, and evidence of those statements came in at the prelim. But on that issue, they thought he was lying.
Well, I need a further refinement here, further clarification then. Is your case based on him being an accessory after the fact, based on the fact that he possesses the knowledge of where the body was buried, or is it based on the fact that he assisted in helping get rid of this body? That's what I need to know.
That's what it is based on.
What? Which?
I'm sorry, I didn't answer that question very well. It is based on him saying that he helped Jeffrey Willis dispose of his body, not where the body itself is located. So we're sort of confusing the two issues here.
Now,
our belief that he knows about the whereabouts of the body is one of the reasons, the primary reason why we believe that he should not be released on bail.
Okay. Yeah. Now, are you saying, is that accurate? Did he tell the police he knew where the body was and he helped get it there?
Yes. And then he took them to that location.
But he did tell the police he helped dispose of the body?
In that location, yes.
Okay. All right. Well.
But, Your Honor, I really believe that a statement on the court's or the state's position isn't clear and convincing evidence. It's just a statement of their theory. They haven't presented any clear and convincing evidence that he's a danger to society, other than the initial he's been charged with a crime, Your Honor. That's obvious.
A crime to which he confessed. And again, what better clear and convincing evidence could you have that a person helped somebody else commit a crime than saying, I helped this person dispose of the body?
Okay, well, we can be going back and forth all day unless you've got something new you want to bring to the table here. I'm ready to rule.
Oh.
Anything further you want to say, Mr. Hayes?
No.
All right, well, with regard to the motion to quash, the court finds that, and I thought I had analyzed this correctly coming in here, based on the motion itself and review of the preliminary examination, and the closing argument confirms that I believe I have analyzed this correctly. This case is not a case of collateral estoppel or involving any due process claim, in my opinion, based on Ash versus Swenson. The question is, could a verdict have been grounded on an issue other than the one that the defendant seeks collateral estoppel on? When I say the verdict, I'm talking about this previous conviction for lying to the police. And the record establishes, based on what I've heard here from the parties, that the statements that the defendant was convicted of to be lies to the police are not the statements that are being relied upon to proceed with the prosecution for an accessory after the fact. Indeed, they were part of the same interview, but the interview encompassed more things than apparently this defendant's knowledge about the involvement of Mr. Willis in the homicide of Jessica Heeringa. It involved his own involvement. Those are two separate, distinct issues. And the conviction for the lying to the police was for the involvement or his knowledge of Mr. Heeringa's involvement in that offense. The accessory after the fact is based on his statements regarding his own involvement as an accessory after the fact. And for that reason, the issues that were decided in the previous conviction are not the same issues that are before the court here today on the matter of accessory after the fact. And therefore, the court denies the motion to quash with regard to its reliance upon a theory of either collateral estoppel or due process. Now, the corpus delicti rule is a different issue. However, the prosecutor's analysis of People versus King is correct, in my view. The corpus that is referenced in a accessory after the fact is the underlying charge itself, which is in this case the homicide. And there's already been a preliminary examination. Apparently the parties agreed to incorporate the evidence presented at that preliminary examination into the preliminary examination on this charge for accessory after the fact, and there's already been a finding that there's at least probable cause to believe that there was a homicide involving Jessica Heeringa, and that would suffice for establishing the corpus delicti in this case then, because that was part of the record in this case. Now, with regard to the matter of the bail, as I recall, the court has already reduced bail once in this matter, if I'm not mistaken, correct?
On a different issue, Your Honor.
Pardon?
On a different issue.
Yes. And the court had an opportunity to analyze all of the factors in that regard. And so the only new issue here, but it's a big one, is the passage of time. Because now we're in a Rule 6004 mode, which requires that this defendant be released on a personal recognizance bail because sufficient amount of time has elapsed between the day he was charged and today that the court rule requires that. And the only exception to that is if there is clear and convincing evidence to this court that this person presents a danger to the community or to any other person, or that he will fail to appear. I've heard nothing here with regard to a clear and convincing argument that he is going to fail to appear. I have heard nothing here to suggest that he is presenting a clear and convincing case for danger to another person. But I have clearly heard a clear and convincing evidence that he's presenting a danger to the community. And that being that he has admitted to the police that he assisted in the disposal of a body in a homicide investigation. That to me presents a very clear and present danger to the community. Why do I find the evidence clear and convincing? Because he admitted it. The motion is denied. You may prepare an order, Mr. Roberts.
Thank you, Your Honor.